Strata Bites, your Strata update with Frank Higginson.
A remedial action notice, or sometimes referred to as a breach notice from a body corporate, is effectively a declaration of war against you as the manager. So these things are documents and notices that need to be dealt with urgently. The way the legislation works is that there's a specific time frame in which you've got to respond, and if you don't respond to the allegations, then it's not necessarily deemed acceptance, but it's certainly not helpful in terms of defending that going forward. So if you get a remedial action notice, make sure you get legal advice straight away. There's simply no ifs or buts about that. And from our end, when we have a client who gets served with one, we start a bit of a process. Obviously, you need to understand what's going to happen next and how it works. And from our perspective, the remedial action notice should detail what it is alleged that you haven't done, and perhaps even what you're required to do to fix it. Now, one of the difficulties with dealing with these types of disputes is that there obviously is a multitude of cases on remedial action notices throughout QCAT and the courts over the years, and some of them are actually, unfortunately, a little bit inconsistent in terms of what needs to happen. So part of the art of dealing with these is making sure that they're approached in the right way. But if you want to really sort of get to the core of it, you might have a remedial action notice that has, say, 9 complaints. The first thing, and again, in terms of solving problems, is if there's some breaches that are arguable but easily fixed, just go and fix them. That takes that issue away. If there's some breaches that aren't actually a duty under the Management Rights Agreement or related to the Code of Conduct or something like that, then those can be knocked away on the basis that you're not obliged to deal with them. The third one, or the third class or type of breach, are the difficult ones that are arguable and potentially grey. Those are the ones where we need to spend most of our time and attention making sure that the response is appropriate. But either way, all of those things need to be dealt with. What happens after that is the body corporate will decide, and usually the committee, whether it's appropriate to try to call a general meeting to terminate the agreements or accept the responses, which quite possibly will be the case as well. If the body corporate resolves to try to terminate the agreements, what you've got to do, by your lawyers, is apply to QCAT for an order preventing any resolution to terminate being acted on until such time as the dispute about the validity of the remedial action notices or the duties that they're alleging weren't performed are dealt with. And that is a proper court proceeding. So I suppose the nutshell of this one is if you get something that looks like a breach notice, remedial action notice, something formally on letterhead saying that you're actually not doing your job, make sure you get legal advice straight away, because the clock is ticking in terms of your time frame to respond, and it's really important that you respond in the right way and rather forcefully if needed to make sure the body corporate knows your position. So again, if you get one of those things at any stage, just reach out because we need to help urgently.